everyone. Welcome to my Legal Matters show this week, Saturday, May 3rd. We are doing Legal Matters today. Thanks for joining me, Judge Desire for Knowledge, as I do my Legal Matters show monthly every end of the month. So the end of the month ended up being on a weekday, which cannot be taped because I'm working. So therefore, I'm doing it today, and I won't be live. I'm sorry. I have some things to take care of, events, and so I am uploading this as soon as I can so that you can get it at my regular 3 o'clock. We will resume to Know Your Truth Real Talk next week. It'll be about mothers and Mother's Day weekend. So I look forward to talking to you guys, mothers and all, actually, and sharing my opinions on motherhood with you all. But in that case, in any case, thank you for coming back or joining, subscribing, and liking this show and my channel. I really do truly appreciate it. And so, with that being said, this week's Legal Matters is Wills, the Basic Steps for Laypersons, Session 2. Last month I did Session 1, and this time I said I would come back and go over a few things that I stated I would in my last video. If you want to check that out, it is the same title on Legal Matters, Wills, the Basic Steps for Layperson, but it's called Session 1. And you could go find that out in last week's show, I believe, last month. Right. So if you look for April, that Legal Matters show is the first part of this, and this is the second part. So as I was saying in the last shows, New York State courts have electric filing as an option to going into the courthouse to file a petition instead of, in contrast to filing in the courthouse. You now have the opportunity to do it from your home, from a library, or wherever you have access to. But as of April 26th of 2022, New York County Surrogate's Court will no longer accept electronic filing on accounting and miscellaneous proceedings. And I'll explain what those things are later. But you need to know, if you live in New York State, or in the county of New York City, New York County Supreme Court Surrogate's Court will no longer be accepting electronic filing on their accounting and miscellaneous proceedings. This all has to do, surrogate court has to do with living people that created wills or not created wills. They intervene on helping those people to assist to their heirs, their estates, their assets, anything that's going to be probated because of a will, and things that happen because you don't have a will is also what is done in the surrogate courts, which people call it a probate court. But surrogate means a lot more than just probate, and I'll explain them. First, we're going to explain the basic procedures for filing a petition in New York State courts. This one being surrogate court is what I'm speaking of now. And this is the basic procedure of filing a petition with a will. If the assets, and this may have changed, but it was over $50,000, you'll have to file a probate petition. If under 50,000, then you would have to file a small estate affidavit, which is a legal form that allows individuals to claim a deceased person's assets without going through the full probate process, where one can transfer the deceased property to their heirs or beneficiaries, especially if it's a small estate. So if it's a small estate, it's best that you don't have to do much, and it doesn't have to be probate. It won't, because it's under 50,000. It's a small estate, and so you will need, for these things, to file the petitions for these things, whether it's over $50,000 in assets accumulated or under. First of all, you would bring to the court an original will plus one copy and do not remove the staples, because once it's stapled together, that's what the person that either at the court staples it, or you come in with it stapled from the person that deceased and had the will created. It will prove that nothing was added or subtracted from the will. So do not remove staples. The courts will then have to see if that was a valid will or not. And then it can be probated if it's found invalid or voided because of it. The next thing you want to do is bring the original death certificate, names and address of all the heirs that are on the will, location of the assets to be claimed, name of all the creditors or debts owed, for example, funeral expenses, utility bills, credit cards, everything like that, because in probate they can freeze your assets until all your debt is paid. So no family, children, wife, no one can get anything if those aren't taken care of first. Next is names and address of anyone named in the will, which are the heirs, the beneficiaries. Once that is all together, those things are what you're going to need to go into a court with the will to have it processed, to fulfill the proceeding of this estate, legally anyway. Now, without a will, if assets are worth over 50,000, you file an administration petition. Okay, not the same as when you have a will. So without a will, if your assets are worth more than $50,000, you file an administration petition. If not, then a small estate affidavit, as we stated, which quickly releases, much quicker than going to probate. So without a will, if the 50,000, if it's under 50,000, you still go to a small estate. You still file a small estate affidavit where they would release the funds to you, as I stated with a small estate affidavit is. Um, it releases and liquidates all the properties to their heirs and beneficiaries. Once you fill that out, it's less proceeding than having to deal with probate court. So usually when it's a small estate, this is what happens. You will fill out the small estate affidavit. For that, you will need, this is without a will, and you come to the court, but you cannot find a will, or there wasn't a will made at all. You will need the original death certificate, names and addresses of the heirs, just like the last one, location of assets, and the names of creditors and debts owed as well. Okay, now we want to go to where the will and documents should be filed. So the documents and petitions are to be filed at the closest surrogate court. You can call it probate court if you need to, um, in the county where the deceased lived or last resided. Now, if you're in a small county, I believe in New York, you should be able to find a surrogate court in a bigger county and close to you. And sometimes Supreme Court will override. They will definitely get involved if needed, and they're supreme over surrogate court anyway. So if it starts in the Supreme Court, it's going to stay there. That's if they don't have any surrogate courts in the area. So that's when they get involved. But as I stated, in the will and trust should be filed in the closest surrogate court in the county where the deceased lived or last resided, which is really important for you to know that. If you're a relative, wife, or anything, you can't just go to any court. You have to know your jurisdictions. Jurisdictions is the place, not just the venue, but what type of court it needs to be filed in is what jurisdiction means. It just doesn't mean the venue. It's what type of case, where the case is needed to be filed, and etc., etc. But we'll do that on another day. And what happens when you are not named in a will? So let's say you weren't named in the will and you expected that. you are actually not entitled to inherit under the laws called intestacy laws. Um, However, one might and still have a claim as such if you can challenge the will in court, or if the will is invalid. Like I said, if something is missing, or they see the court see, or someone can make up entertain a case of well, this there was a staple on this, or things like that, like I just mentioned, and you could see a staple mark, so something could have been added or subtracted. So therefore, that would be a claim to challenge the will in court. Or if the will is considered invalid, it will be done so by the court's ruling, not by a person. You could come in and fight that, but it will be up to the court ruling to decide that. um, Now I'm going to describe the parts of the court in surrogates, and specific things and specific filings that are done there in each part of the court. So we were talking about miscellaneous part. So miscellaneous part is where the affidavits of service is filed, and the jurisdictions of the applications are verified before accepting to the courts. I know it sounds funny. I'm trying to be as easy as I can for a layperson that I am. I don't want it to make this difficult, but miscellaneous is just what it says. Miscellaneous, everything is thrown to that part of the court. Little things like where's the affidavit of service is filed, you have to get those accepted by the court. If it wasn't, the case does not go through. The jurisdictions of the applications are verified before accepting, which I said, is this the type of place where this case belongs? Is this the place where this case belongs? Those type of things. That's what miscellaneous part does. And then my favorite part, because I worked this part before, accounting part. This part does the accounting of the estate and distributes what's owed to the heirs of the deceased. This is where the estate monies are liquidated to the individuals in a will, trust, and or an estate. These things are important because this is where all the accumulation of your inheritances and everything that needs to be dis, distributed to those that are named as a beneficiary, as an heir, wife, husband. It doesn't matter whether they have a will. If you're legally married and not legally separated or divorced, they can still claim your funds, just to let you know. You have to clearly make that if there's a divorce in any form or manner, because things happen and we don't know about. But this is how people are able to attain money, even if they don't like you, they hate you, you hated each other, whatever the case may be, there was a dislike. Those are the first people to come for your money. So you want to make sure that you do have a will, and that it actually states, whether it's a living will, a will, last testament, whichever one you choose. I am not an attorney. You have to make that decision on your own. But there are various amounts. It's really better to obtain an attorney if you're not familiar with the laws, surrogacy laws, because then you would better understand what you're doing and who can and cannot touch what you have when you're not here. And so, like I was saying, the accounting part is where the distribution comes of the checks. They also have GALs, gals, guardian ad litems, that actually take cases where there are people that are not able to take care of themselves, whether adults or young children, that were left monies. The GALs, the guardian ad litems, they're the ones assigned to the case to distribute the money. If there's not someone within the family, the court does appoint the GALs. All right. And guardian adoption part, this is where infants are provided guardians and are adopted. It sounds the same, but it's a little different. There's also an infant 17A applications are filed here. Those are used to appoint a guardian to a child, to an intellectually disabled child, or developmentally disabled as well. Sorry, I didn't say that word, developmentally disabled, which is a lot more than you think out here. So they're assigned as well in those guardianship, that part of the court. is where adoptions and all type of guardians things go on there with children underage. It's more or less like family court with that part. Probate part, this is where the descendant who left a will would have it in probate to contest it after death. So, in other words, like we said, if it becomes probate, it was usually something that's a lot more than 50,000 in assets or in your estate. It will go to probate. This is where the will that was left will be put in that part. That's why they always call it probate court, but it's actually a probate part. A surrogate court is not only based on probate, so that's why we don't call it probate court. We call it probate part because there's different parts in surrogates court that um, is needed for some people, and some people won't even ever see the other parts. It's just that whatever the will or not, the ability of not, the ability of having a will and not having a will determine which part you'll be sent to when you go. It's just I'm familiarizing you with these parts so that you'll know. You can rewind this tape and see which part is more or less something that you assume would be where you would need to go, but always ask when you get there, or you can call the courts of your county to see exactly where which department you would need to be, what part of the court would you need to file your claim, your petition. Administration part and small estates, this is where a person who did not leave a will files. Um, so the family would go to this part to see what they can do to get whatever assets were left but wasn't put into a will. And then we have a cashier certificates and certifications which are given to the cashiers. These certificates and certifications are paid for. This is where your filing fees are paid. This is where all the court fees are paid by the public and or attorneys. And this is where you get your certificates and certifications from. They can let you know what type, this many. And record records. There's also a records and search part. People can search for records that were filed in that court, especially if they were in probate. Record search, that's a department. And then there's the help desk. That part assists those who do not know how to file a case or use or they're not technically literate. They're technically illiterate. They do not know how to function on a computer, and you believe it or not, there's a lot of people that don't. Then we have this law department where records are received here for their review, the law department's review of complicated cases. They read legal briefs, things like that are sent to the court, and it goes through the law department. A lot of stuff goes through them. And then, like I stated in the last show, New York County Public Administrator, which is that person that puts it, they take care of the descendants' estate and searches for unknown heirs to the estate. Like I said, they go through public notices, and they will look that up and try to find the heirs through public notice or any way that they can through investigating the estate that was left without a will. Which normally, if there's no live relatives, the state will then put in a public administrator to do that for them. I'm not sure if that's free of charge, but I think they do get a part of the state monies once they find the families and stuff like that, because they do need the money to make the investigation work, right? And so, last and not least, people have been doing this lately. I've seen it when I worked in the surrogates before. An apartment can also be searched for a will. Okay, let's say that you think that this person had a will, but you have no access of getting in there, and you don't want a criminal record. You can go to the court, the surrogates court, not the police, the courts, and you can file a apartment search petition. And with that petition, it will enable you, along with the police, to go and search that apartment for a will. And therefore, finding one, you have a witness, which would be the officer there, seeing that you have not touched or done anything to affect that will. And so, with that being said, I'm thankful that you joined me here today on this beautiful Saturday. And I want to say, on my next legal matters, I may do a um, wills versus trusts so that you can see for yourself which one is a better option for you. I'm believing the trusts are, and I'll let you know why. But again, it's up to you. I'm not an attorney. I just advise some people, not even advice. Well, um, being with my experience, I've been working in the system for years and I've worked in each part. So I try to give what I've learned, research to see what updates have been coming through. But I'm not an attorney. You would need to know what to do for yourselves. But I'd like to assist. Consultation is what I'd call it. Consult. That's what I do. And so, therefore, if you cannot understand any of these simple, basic formations that I have been doing on my video, you will definitely need to seek an attorney. I would suggest that, but it will cost you. And there are legal aid attorneys as well out here. So if you're not making enough money and you can prove that either to the court, they will assign you one, or at least get you someone that is close enough to give you the information on where to go, at least. Okay? So there's the legal aid, and if you make too much money, then some other way you'll be given some alternatives. If not, then you have to find your own attorney. But you can start with the legal aids first if you cannot afford it, and I'm sure they'll give you a great overview of what to expect. And with that being said, please like, share, and subscribe on this channel. As I said, next week will be Know Your Truth Real Talk. Have a great weekend. I look forward to a live next week. All right, ladies, let's take it on. Tell your truth on Know Your Truth Real Talk. Come and tell it. Yeah, let's talk about it, right? So, here on Legal Matters with me, Judge Desire for Knowledge, where I bring the truth and nothing but the truth, is adjourned. And I will see you next week. Enjoy your week. Go check out my shorts. I've had them out. I'm out and about is on my trips and all the events. I'm putting them up this weekend. If you didn't see it, come check it out on YouTube. All right. My videos are boxed down there. Go check it. All right, child. Take care, JD4K family. This is Judge Desire for Knowledge. I'll talk to you soon.